arbitrationagreements.org. Hello everyone, and welcome to our discussion on an important aspect of alternative dispute resolution, specifically the enforcement of arbitration awards in the United States. Before we begin, please like this video, press the subscribe button, and tap the bell for notifications so you can keep up with crucial dispute resolution topics that can save your business a great deal of time and money. When parties agree to resolve their disputes through arbitration, the decision made by the arbitrator, known as an arbitration award, is not merely a suggestion. It carries the force of law and can be enforced much like a court judgment. The Federal Arbitration Act, or FAA, enacted in 1925, provides the legislative framework for enforcing these arbitration awards nationwide. In general, parties seeking to enforce an arbitration award must apply to a court that has jurisdiction over the party against whom enforcement is sought. There is a notable fact to understand. According to studies, approximately over 80% of domestic arbitration awards are voluntarily complied with, without the need for court enforcement. This is likely due to the reputational and financial incentives for parties to adhere to their arbitration agreements and comply with awards. If an award is not voluntarily complied with, the FAA allows the party who is owed the award to petition a local, federal, or state court to confirm the award. Once the award is confirmed, it has the same effect as a judgment of that court, and the court can use its power to ensure the award is complied with. For international arbitration awards, the United States is a party to the 1958 United Nations Convention on the Recognition and Enforcement of Foreign Arbitral Awards, also known as the New York Convention. Under the New York Convention, the U.S. and other member states have agreed to enforce arbitration awards made in other member countries. This has helped facilitate the growth of international business, with studies showing that as of 2021, 167 countries have signed the convention. This means you won't have to worry if your business gets involved with a company or individual based overseas. Under very rare circumstances, courts can refuse enforcement of arbitral awards on certain grounds. These grounds include incapacity of a party, invalidity of the arbitration agreement, denial of due process, and awards that are in conflict with the public policy of the country where enforcement is sought. This refusal is rare though, with recent research indicating that U.S. courts denied enforcement of domestic and international awards in under 5% of cases. We hope this discussion provides a clearer understanding of how enforcing an arbitration award works in the United States. It's a testament to the efficiency and effectiveness of alternative dispute resolution mechanisms. Do you need more information about arbitration? If so, visit arbitrationagreements.org. That's where you can buy the service or program you need right away and begin the dispute resolution process quicker. Now, our association does not provide any legal advice, but give us a call if you or your business are considering opening a new account or case. Countless companies and individuals utilize our services to handle claims in a controlled manner through cost-effective solutions. If you're interested in doing that as a business, we are standing by. Also, what do you think about arbitration? Does it sound like a solution for resolving a dispute? Give us your opinion by leaving a comment below. Don't forget to like the video, hit subscribe, and ring the notification bell so you can stay up to date about alternative dispute resolution processes that save time and money.